Hello, everyone, and welcome to ACS Webinars, connecting you with the best and brightest minds in chemistry, live from Washington, D.C. I'm Eric Holderman, and I'll be your host during today's webinar, which we are proudly co-producing with ACS Careers. Are you a foreign scientist wanting to maintain your status in the United States and eventually qualify for a green card? During the next hour, we hope to teach you how to obtain a green card in the U.S. through the employment-based first preference visa and the national interest waiver categories. We'd love to get you involved in the discussion. You can share your thoughts and questions in the questions panel. You can also join the discussion on Twitter by including @American Society in your tweet. The slides for today's webinar can be accessed right now by clicking the link that you see in the GoToWebinar control panel. An invitation email to view the unedited recording from today's presentation will be sent to all registrants for a 24-hour period, after which it will be removed, edited, and posted to the ACS webinar library as soon as possible. Our moderator today is Tom Halloran, who oversees the ACS Career Consultant Program at ACS and acts as staff liaison to the Committee on Economic and Professional Affairs. Tom has a BA in Political Science from the University of Miami and has an MBA from the University of Maryland. And with that, Tom, I'll turn it over to you.
Great, thank you, Eric. It's exciting to see such a great turnout for today's webinar. Before we get started with today's presentation, Green Cards for Scientific Researchers, I'd like to say just a few words about today's presenter, Brian Getson. Brian is a graduate from the University of Pennsylvania Law School with more than 25 years of experience. He is a leading U.S. immigration lawyer who represents scientific researchers in applying for green cards and is the principal of a boutique immigration law firm based in Philadelphia, PA. Mr. Getson has given presentations on green cards for scientific researchers at numerous major scientific conferences, the Wistar Institute, and at universities. Mr. Getson often provides a money-back guarantee to qualified applicants, giving clients confidence that they will get results. Brian, we're grateful that you're taking the time today, and with that, I'll hand it over to you.
Very good. Thank you so much for having me today, Tom. I really appreciate it. So again, my name is Brian Getson. I'm a graduate of the University of Pennsylvania Law School, and I have been practicing immigration law for more than 25 years. I am the author of a book called Obtaining U.S. Visa Based on Achievement. I am based out of Philadelphia, PA, but immigration is federal law, so we represent clients throughout the United States and throughout the world. So the Trump era is over, and everything that everybody was worried about during the Trump administration, such as, not being able to get visas at consulates, taking away STEM OPT EAD, taking away the H-4 EAD, that is all in the past. And we're in the era of the Biden administration, and the Immigration Service is open for business. They are approving cases, and if you're looking to live and work in the United States, now is a good time to do so. So today I really want to break the webinar into two parts. The first part is about maintaining your right to live and work in the United States, your underlying non-immigrant status. And then the second part is your qualifications for a green card. And there's an interplay between those two things. You want to make sure that you're always legal in the United States and have the right to live and work. And then you want to think about what is the best time to apply for the green card within the context of your non-immigrant status. So if you're already here in the United States or you're looking to come to the United States, you're either going to come as a student or to work. And if you're a student, you're in F1 status. And if you're working, you're either working in a university setting as a postdoc or a professor, or you're working in industry. And there's various non-immigrant statuses for you to be able to work in the United States. So there's also a difference in the non-immigrant statuses if you're working in postdoc or in industry. I always tell everybody to take whatever job you want and let the immigration follow. don't take a certain job because you think it's going to help your immigration. It might not work out. You want to be happy with your job and your career. So you should certainly do what you would like, but you need to understand that the options are different, and it's always easier to maintain your status in an academic setting than it is in industry. So when you're interviewing for jobs, the more knowledge you have about your immigration options, the better. That helps when you're speaking with prospective employers, and you want to make sure that you're on the same page with your employer about how they're going to sponsor you in order to maintain your status. So if you're in F1 status, then after you graduate, you have 3 years of work authorization that's called optional practical training. And as long as you're working in a field related to your degree, you can work either in industry or postdoc. Now, if you're in a postdoc at the end of your 3 years of OPT, or if you're coming from outside of the United States into a postdoc, then you have the option of an H-1B visa, and that is good for 6 years, and it can be extended beyond 6 years if you are in the process of applying for a green card. There's something called J-1 status that you're eligible for in an academic setting, and that is good for 5 years. And at the end of the 5 years, you could then go to H-1B for 6 years, and then it might be possible to obtain a green card maybe during the OPT where you wouldn't need sponsorship afterwards, or you can also apply for a green card from overseas. So if you're in industry, you have, again, the same OPT 3 years. Your industry is also eligible to sponsor for H-1B status, but there's a lottery to see who gets H-1B visas for industry. In other words, there's a limited number of visas issued each year, and there's a lottery to decide who gets them. And in the academic setting, there's an unlimited number of H-1B visas, so you can be sponsored at any time. J-1 status is not an option to be directly sponsored by industry. And then there's also an O1 is an option for use in industry. If you don't win the H-1B lottery, or you want to transfer from academia to industry, or you want to take an industry job from overseas, that's usually the main uses of the O1. And then you could also potentially apply for a green card during your OPT or otherwise while you're in industry. So this is the basic overview of how you maintain your status in postdoc or industry. And now we're going to talk about each of these individually. So during your OPT, so can you apply for a green card during your OPT? The answer is yes, but you need to manage the visa backlogs. So there is a limited number of green cards issued each year, and the demand is exceeding the supply right now in nearly every category, every classification. So there is a wait. So there's 2 steps to apply for a green card in the US. There's what's called the I-140 petition, and you can file that at any time. And that is demonstrating to the Immigration Service that you're qualified for a green card based on your research accomplishments. And then there's the I-485, which is the actual green card application. And you can only file the I-485 green card application if the priority date, which is the filing date of your I-140 petition, is current in what's called the visa bulletin. So if you're going to apply for a green card during your OPT, you need to manage the expiration date of your OPT and your STEM OPT EAD. In other words, you have 12 months initial and 24 months STEM, 3 years total. And then, you need to manage your credentials as well in terms of whether you're eligible to apply for a green card during the OPT. So if you're from China or India, it's almost going to be impossible to get a green card during your OPT because of the backlog. If you're not from China or India, then it may be possible. So it's something to consider. If you could get a green card during your OPT, then you don't need to worry about the H-1B lottery if you're in an industry situation, and likewise in an academic situation, you wouldn't need sponsorship. So the H-1B, again, during the postdoc, there's no lottery, it's CAP exempt. You can be sponsored for H-1B in a university or a national lab at any time. With industry, you have to go through the lottery. So the lottery runs in March of every year for a period of, a little less than 3 weeks. And the way that the lottery system works is that the USCIS has an online database, and the company registers basic information, and then you register basic information about yourself, your name, your birthday, your passport number, and whether you have a US master's degree or higher. There are 85,000 total visas. There's 65,000 regular visas, and then 20,000 for people with US master's degrees and higher. And the lottery that just took place in March of this year, it was the highest number of applicants ever. It was more than 750,000 applicants for the 85,000 slots. And USCIS selected about 110,000 applicants because, they oversubscribe because not everybody applies, and then some cases are not approved. So that's really tough. I mean, it was like a 14% approval rate. And, what the explanation for it is that before they had the lottery, you used to have to submit your whole petition to immigration within the first 5 days of April. And so, there were more barriers to entry into the lottery. With the new system, you just have to register online and pay $10, and that's all it takes to register. So it becomes very easy for companies to register. And then what happened this year is that certain companies, they sort of gamed the system, for lack of a better word, and they sponsored people more than once with different corporate entities. And, the Immigration Service is looking into that. So, there were literally hundreds of thousands of people that were entered twice into the lottery, which made the numbers go higher. So I'm not sure what's going to happen next year in terms of changes, but that is the explanation. So what happens if you're in industry and you don't win the lottery? Well, you either have to have a green card, or you have to be sponsored for O1 status, and O1 is the non-immigrant equivalent of EB-1A extraordinary ability, or you'd have to go back to a postdoc. So, you sort of have to manage this, understanding that the lottery odds are not very good. So if you're in academia, we talked about H-1B or J-1 as being an option. So why is H-1B better? Well, number one, H-1B is what's called a dual intent visa. So if you have H-1B and you file for a green card, an I-140 petition, or even the I-485, there's no limitations on you being able to travel outside the United States or extend your H-1B status. And also, if you have a green card in process, you can stay in the US beyond 6 years if you need to because of the backlogs. So you don't want a J-1 unless you have no choice. And the J-1 is a non-dual intent visa. So if you file an I-140 petition, I would not want you traveling outside of the United States and returning with a J-1 visa. Certainly, if you apply for a J-1 visa at an embassy, it could be denied if you filed an I-140. A J-1 has something called a 2-year home residency requirement, where you can't hold H-1B status or a green card unless you go back to your home country for 2 years or obtain a waiver. It's normally very straightforward to obtain a waiver through what's called a no objection from your home country. But, if you can have the H-1B and avoid that, that's better. But, usually there isn't a problem getting the waiver. But most university postdoc positions want to put you into J-1 status because they can pay you less. When do you use the O1? So again, it's typically only for industry. The only time we really use an O1 in academic setting is if someone is a Fulbright scholar, and in Fulbright scholars, it's nearly impossible to get a waiver of the 2-year residency requirement. So if you want to be working in the US, you need the O1. So the O1, again, it's mostly used for industry. If you don't win the H-1B lottery, then you should be talking to your employer about an O1. And again, I mentioned earlier having open lines of communication with your employer. So if you're working in OPT, number one, make sure your employer is going to sponsor you in the H-1B lottery. And number two is talk to your employer about, well, if you don't win the H-1B lottery, are they willing to sponsor you for O1? Having those conversations during the interview process is good. If you're subject to the 2-year home residency requirement, you can still hold O1 status in the US. You can't change your status, but you could leave the US, apply for an O1 visa at a US embassy and come back. Sometimes if you start the green card process too late and you can't extend the H-1B beyond 6 years, then you could hold O1. And probably the most common use of the O1 is somebody who's in academia, they're in H-1B, in a cap exempt situation, and they want to transition to industry, and you would do that with an O1. The legal standard for O1 is much easier than for EB-1A. There's different regulations, there's different, the way that USCIS interprets the categories is different. So it's definitely easier to get an O1 than in EB-1A. And in many cases, people that have O1s approved, they don't get an approval for an EB-1A because it's harder. So that's the context of the non-immigrant status. So now, how do you apply for a green card? So the most common way that foreign nationals apply for employment-based green cards is through a perm labor certification. And you need an employer to sponsor you, and the employer has to do recruitment that is governed by Labor Department regulations. They have to advertise the position in 2 Sunday newspaper ads, and then 3 other sources of recruitment, like on their website and monster.com. And they have to show a lack of US worker availability. All of you listening right now, you want to try and avoid that labor certification. You want to try and apply for a green card based on your research accomplishments. And there are 3 categories to do that. There's EB-1A, which is called extraordinary ability, and you can file that on your own. There's EB-1B, which is outstanding researchers or professors, and you need an employer to sponsor you, either an academic employer or an industry employer. And then there's the EB-2 national interest waiver, and you can file that on your own. So the difference between the 3 categories is the wait times, which I'm going to get to in a bit. So now, you want to have a filing strategy in terms of the green card. So you want to have a roadmap in terms of where you're going, right? What is your non-immigrant status? How are you able to maintain your non-immigrant status? And then you also need to have a backup plan, because say the petition that you file is not approved, then how are you going to manage that? How are you going to handle that? So you never want to bury your head in the sand when it comes to immigration. You want to sort of plan for the, all scenarios in terms of understanding the strategy and when to file. So when I'm speaking with clients to figure out the best strategy and timing, you're sort of putting a bunch of different issues into a pot, and you're analyzing all of these different issues and then coming to a decision about when to file. So the main issues are, number one, when does your current non-immigrant status, and can you extend your status or change your status? So in other words, if you're at the end of your J1 status and you can't be sponsored for H-1B, and the green card might be the only way for you to keep living and working in the US, then you might need to file sooner rather than, if you could go to H-1B and you could wait. So again, you want to sort of understand what your status is and how you're going to always be able to live and work in the US. Then number two, are you in industry or a postdoc? So if you're in industry, you might not be publishing anymore. You probably won't be. All of the work that you're doing is proprietary. So you might speed up the process compared to if you're in a postdoc where you're going to keep publishing and presenting. Most important, how strong is your case now, and will it improve in the near future? So nothing matters unless your case gets approved. So you certainly don't want to file too early where you would risk denial. But, if your case is not going to improve by waiting, if you're going to wait a year and it's not going to look any different than it does today, then there's no point in waiting that year. So, analyzing your credentials is really the number one factor in the strategy and the timing. And sometimes there's family and job considerations. Sometimes you need a green card for funding or a security clearance. Sometimes spouses are living in different cities, or you need an H-4 dependent to get a work permit. So all of those factors go into the strategy. And again, this is on a case-by-case basis. Your case is unique to you. You have your own job, your own non-immigrant status, your own credentials. And the law evolves too. So what happened to your friend is not you, right? So, again, keep the case particular to you. So now, how do you get a green card while avoiding the perm labor certification? So the starting point of everything is the visa bulletin, the different categories, and what country are you born in. So as I indicated, there is a limit on the total number of green cards issued each year, and no one country can have any more than 28% of the total green cards. So right now, there is a backlog to file the I-485 green card in every single category except EB-1 for the world. So if you're not born in China or India, then you're looking at these dates. You're looking at the dates being current in EB-1, and then there's a backlog in EB-2 NIW. And there's a backlog for the world in NIW for the first time in my entire career for an extended period of time. So the visa bulletin tells you what the backlogs are, and this is published each month by the State Department. And if you Google visa bulletin, you can, see it each month. There are two different charts in the visa bulletin. There's something called the dates for filing chart, and then there's something called the final action date chart. The dates for filing chart means the date you can file the 485. The final action date chart means the date that immigration can approve the green card. Right now, the Immigration Service is not using the dates for filing chart. They are using the final action date chart for both. So that usually changes in October when the numbers reset and the government fiscal year starts over. But right now, the final action date chart governs everything. So if you're from anywhere other than China or India, and you're looking at a wait of a little bit more than a year to be able to file the green card application after you file your national interest waiver petition. If you're from India, the wait is more than 12 years. And if you are from China, the wait is approximately 4 years in NIW. Then when you move to the EB-1, there is no wait for the world. The wait for India and China is a little bit more than a year. So it is human nature to not want to wait. Everybody wants to wait less. So everybody wants to file in the EB-1 category. No matter who I talk to, you want to file in the EB-1 category to wait less. And especially people from India, where the wait is so very long, it's all understandable. And I empathize with everybody who wants to file EB-1. But understand that it's really hard, because since everybody wants to file EB-1, what's happening now is that it's the highest level of applications ever that the Immigration Service is receiving in EB-1. And it's also the highest rate of request for evidence and the highest rate of denial. So you have to be very strategic about how you go about filing, because you are allowed to file as many petitions as you would like. But if immigration denies you once, they are almost certainly going to deny you twice. So you have to take a step back and understand the visa bulletin and what the system is and the weights, and then be smart about how you go about filing in terms of the NIW and the EB-1. So sometimes it makes sense to file an NIW now and an EB-1 later. So for example, you're in OPT status with 175 sites and no significant positive factors, and you're unlikely to win an EB-1. So if you file an NIW petition first, then it establishes a filing date, a priority date, that you can then substitute into a future EB-1. So in other words, if I file a NIW petition today, May 11th, 2023, and it gets approved, I own that date forever. And then let's say I file an EB-1 petition in 2025. Then when I file the EB-1 petition in 2025, it's as if I am filing the EB-1 petition on May 11th, 2023. Now, what does that do? Well, it allows me to grow my credentials, namely my citation level, to give me a more reasonable chance for EB-1 approval, and I'm not losing any time in the waiting line. And if you're from China or India, you can't file a 485 green card application anyway because of the backlog, so you're really not losing any time. So a really good strategy for people from China and India who, there's a risk of having an EB-1 denial because you're not qualified right now, is to file an NIW and then to get into the waiting line. And then when the priority date of your NIW is close to being current in the EB-1, then evaluate your credentials and whether it makes sense to file. So again, you file your EB-1 once your NIW is approved after strengthening your case. And your odds of EB-1 approval are much higher because your case is stronger. And also, if you have an approved NIW petition already, then immigration knows that you're going to eventually receive your green card. And then they hopefully view the EB-1 a little bit differently, right? They're either going to be nice and not make you wait as long, or they're going to be mean and make you wait in the NIW waiting line. So, you have to think about this strategy, and it's hard it's hard to accept waiting to file the EB-1 because, again, it's everybody wants to file, wants to not wait, but you're not getting the green card any faster with this strategy. Now, if you have a strong EB-1 case, then you should file your EB-1 because it's easier to prepare the EB-1 case together with the NIW. And whenever you're filing an EB-1, you should also file an NIW as insurance in case your EB-1 is denied. So it's similar to car insurance, right? If you're in a car accident, you're glad that you have the insurance. If your EB-1 is not approved and you have filed an NIW at the same time as the EB-1, then you're in the line much earlier for the green card than if you were to wait for the EB-1 to be denied before filing the NIW. And, certainly if you're from not from China or India and you have a strong EB-1 case, then you would want to try and file that to not wait. So premium processing, everyone thinks, oh, I'm going to premium process my I-140 and I'm going to get the green card faster. Well, that's just not true with a backlog. You can't premium process the 485. So it typically doesn't make sense to premium process an I-140 because you need to wait to file the 485 anyway because of the backlog. That's from China and India. If you're not from China and India, then you could consider premium processing the EB-1, and if it gets approved, immediately file for the green card. But, you know, the immigration service is harder with premium process cases. There is a higher incident of request for evidence and denial with premium process cases, so I like to avoid it if I can. Okay, so now how do you win your green card case? So the first method is you have won a major internationally recognized award like the Nobel Prize, and I say good luck with this method. I have never had a client who has won the Nobel Prize, and I don't expect to, and you don't need the Nobel Prize to get a green card. So with EB-1A, you have to satisfy 3 categories of a list of 10. With EB-1B, you have to satisfy 2 categories of a list of 6. And with NIW, all of the evidence counts, there is no set categories. So now I want to walk through the individual categories. So the first is receipt of a national or international recognized award in the field. So this is where the O1A distinguishes from the EB-1A. With the O1A, they will count a young person award, a PhD award that's national or international, you know, an early career award, a conference award. They will count that for O1A. They do not count it for EB-1A. EB-1A, you have to have an award that is open to all researchers in your field at any career stage that is national or international in scope. So that's really hard for EB-1A, but it's more reasonable for O1A. Next is achievement-based membership in associations. So this is a membership where you have to be selected in based on your accomplishments. So just joining the ACS, anybody could join by paying dues, so that doesn't count for immigration purposes. Something like the fellowship level of the IEEE would count. The extreme examples are the National Academy of Sciences or the Royal Society of London. You know, very few of my clients have the membership qualifications, but it is something that you can control, right? You can apply for a membership, and if you get in, it's going to really help an EB-1 case. Next is publish material about you and your work in journals or other major media platforms. So this is other people writing about you, you know, a press release, a journal comment or editorial. And again, there's a distinction here between O1 and EB-1. With O1, they will count the media if it references your publication. With EB-1, your name has to be within the text of the article. So again, this is something that you can control. Every university has a press release office. They like good news about their employees. So if you have an interesting publication, then go to the press office and ask them to do a media article that includes your name and your PI's name. So now the 3 most common categories for EB-1. The first is participation as a judge of the work of others. So this is doing peer review. It's doing peer review for journals in your own name, not for your PI, where the journal is emailing you directly to ask you to do peer review. More is better. 10 is better than 5, 15 is better than 10, 20 is better than 15, and so on. And the impact factor of the journal doesn't really matter all that much. But, you know, you have to have this category if you're applying for EB-1, and it helps with NIW also. So do peer review. Email the journals where you have published. Ask your PI for help. When you go to a conference in person, talk to the journals in the exhibit hall. So, just do as much peer review as you can. Peer review also counts for conferences, but, the journal peer review is usually the best evidence. Okay, so now the category that everybody tries to meet, that you have to, is original contributions of significance. And the way that we prove this is two ways. Number one, with objective evidence, including your citation level. And number two is with reference letters. So now, the objective evidence that we give is, number one is the Google Scholar citation page. So right or wrong, fair or not, citation level is the number one consideration that the Immigration Service uses when deciding green card petitions. For an NIW petition, I like to see 75 plus citations to offer a money back guarantee. We can get cases approved with less than 75 citations. And, this is where I come back to, well, if you're at 40 citations, how long is it going to take for you to get to 75 citations? With EB-1A, it's a whole different story. The Immigration Service, they have just been getting much more difficult because of the number of applications in EB-1A. And they are regularly denying most cases under 1,000 citations. They even deny cases sometimes with more than 1,000 citations. So, and this is where you have to think about strategy, right? So again, everybody wants to file for EB-1A, everybody. So what is the easiest way for the Immigration Service to distinguish among researchers, right? If they're getting 5,000 applications, everybody's a good researcher, everybody's smart, everyone's at a good university, everyone's doing good work. How do you distinguish? Well, whoever has more citations has had more impactful research. That's just sort of a cut and dry way for them to do it. And it's not always fair because certain people's fields are not as highly cited as others. For example, if you're doing research on soil and agriculture, your field's not going to be as highly cited as somebody doing, cancer research. But, that's just what they do. So, you can take steps to increase your citation level. If you write a review article, that's going to be more highly cited than a research article. And network, ask people. If you cite someone, ask them to cite you. Just ask people to cite you, it helps. So, when you're looking at EB-1A, I'm not saying to not file a case with less than 1,000 citations. You just have to analyze your particular situation, but immigration has been harder. And the other thing that really helps with an EB-1A that I have been seeing in my practice is we're talking about the three most common categories: publications, peer review, and original contributions of significance. Well, if you can get to a fourth category, then that really helps. So, we like the media, and I'm going to talk about leading critical roles. So getting to a fourth category really helps in EB-1A. But citation level is number one. Then we give the first page of your publications. So publications count even if you're not the first author. If you are the third author in a publication, there is law that says you are allowed to consider that work as your own. So you can say, Dr. So-and-so discovered this, even if you're not the first author. The impact factor of the journal also really doesn't count all that much. I'd rather you have more publications in lesser journals with higher citations than one publication in Nature. Certainly the publication in Nature is great and it's helpful, but all publications count. Conference presentations, we give the evidence of that. Your proof that you have presented at a conference. Certainly, if you have given an oral conference presentation, that is more impactful than a poster. We give sample articles that have cited your work, where we highlight the citation of your work. The media that I talked about, we would give that if you have any. If anybody else is interested in your work, if somebody has randomly reached out to you by email or LinkedIn or ResearchGate to ask for your advice or expertise or a full text paper, then that is extremely helpful. We're trying to establish you as an expert with immigration. So if other people consider you an expert, then that's good evidence. And then if you have any patents or funding, especially if they're commercialized, then we give that evidence. So that's the evidence part of this. And then you have the reference letters. So when my law firm prepares a case, I give 3 different kinds of letters. The first kind is called an independent letter. And independent means the author has never worked or gone to school where you have worked or gone to school. They're not a co-author, they're not a collaborator. Maybe they met you at a conference, or they cited you, or it's your PI's friend. And I normally have 3 letters from people in the US and 2 from outside, or the other way around. And the independent letters provide an overview of your career. So you're trying to show immigration that people outside of your circle of colleagues are aware of your research and its impact. And all of your work that's publicly available, because it's been published or presented, that anybody could know about, the independent letters discuss them. The second set of letters is from your supervisors. So, your supervisors, of course, they're going to say nice things about you, but I still like to have a letter to show that they're supporting you. Sometimes not everyone can get a letter from their supervisor, but at a minimum, I like to get a letter from the current supervisor to establish that, you're working, and, they would offer you a job if you had a green card. The third set of letters is what we call supplemental letters. And these are short letters. They're normally no more than 2 pages long, and they're trying to show the impact of your work on the field. And, not every law firm does this. This is something that sets us apart, and it really makes a big difference in your case. Is there a private company that's interested in or using your work that could write a letter? Is there a government agency that's funded you or that you've worked with? The Army, the DOE, NASA, can they write a letter talking about your work? People who have cited you, how did they use your work to help their own research? If you've collaborated with other labs, how did you benefit the collaboration? If you were selected or invited to give an oral conference presentation, that's a big deal. Why were you asked to do that? And then if your work is commercialized or funded in any way, try and get a letter about that. So how do we write the letters? Is that you would outline your research for me based on samples that I give you. After you would outline your research, we have a team of science writers that all have degrees in science that are, very adept and skilled at writing these letters, ask questions to make the letters more simple and understandable. And then I would write each letter for you. As I would write each letter, I would send it to you to edit. As it gets finalized, you would send it to the author to sign on letterhead, and then we use a secure file sharing service called Basecamp, and you would upload to Basecamp the signed letters plus all of the evidence. And then once we have all the letters and evidence, we normally do about a 30 to 40 page cover letter to immigration to explain why you're qualified for the category in which you're applying, along with the forms. So our letters are effective because our independent letters, we have them discuss all of the research. I find that to be more effective than having one letter discuss project 1, a second letter discuss project 2, and so on. These supplemental letters can be a real benefit to your case. And then, we avoid problematic language. And, the writing of the letters is the #1 reason to hire, an attorney, because, the attorneys are skilled at writing the letters. Problematic language. Immigration only cares about what you have already accomplished. So you never want to use speculative language in letters. If your work has the potential to cure cancer, it has the potential to not cure cancer. So, you don't want to talk about what may be, what could be, what is promising. That is, that's asking for a denial. Then you don't want to talk about you being a young or early career researcher. Immigration's comparing you to everybody. This is not a green card for young people. Then you also don't want to talk about working as a team. You know, again, the law says that you can count as your own research any research on which you are an author on a publication. And, you know, we have the science writers that help write the letters, and I personally look at every letter that leaves our office. The next category, authorship of articles, and, you know, this is just you're giving the first page of your publications. More is better. Display of work at artistic showcases doesn't really apply to researchers. A leading or critical role. So this is helpful for both O1 and EB-1. The standard for O1 is called working in a critical or essential capacity for an organization with a distinguished reputation. And with EB-1A, it's a leading or critical role for an organization with a distinguished reputation. Leading role has to do with job title, seniority. Critical role is that your work is critical to the outcome of the organization. There was a very positive change from immigration in this category recently, where you can now show that if your work is leading or critical to the department or division in which you work, it counts. You don't need to show it to the whole organization. High salary compared to others in the field. This is usually not the case for researchers, but sometimes, you know, if you're in an industry job, we would try and meet this category. And commercial success, again, this does not apply. So now, what's the EB-1A legal standard? It's you're among the small percentage at the very top of the field in the world that you have received sustained national or international acclaim. Sustained means over an extended period of time. And then even if you meet 3 of the categories that we've been talking about, your case can still be denied under what's called the Kazarian standard, meaning if they feel that by a totality of the circumstances, a preponderance of the evidence that you're not at the top of the field, they can give you 3 categories but can deny your case. So EB-1B, the legal standard is international recognition as outstanding, and you need to meet 2 of the categories. The slide says EB-1A, but I'm talking about EB-1B. Next, you need a tenure or tenure track teaching position or a permanent research position. With academia, this is a research position beyond a postdoc. And with industry, there has to be a permanent research position and at least 3 other full-time researchers in your department or division. You have to have at least 3 years of research experience, and that has to be obtained post-PhD, unless you can show your PhD research was outstanding. And you have the same Kazarian standard of needing to satisfy, you know, even if you satisfy 2 categories, that you still have to meet that standard. For the most part, you're not going to have this permanent research position until you are at least 3 years post-PhD. So EB-1B is employer-based. It belongs to the employer, not you. So, you know, look, EB-1B is a lot easier to get approved than EB-1A. I talked about how hard it is to get EB-1A approved, which it is. EB-1B is a much easier legal standard. So if you're in a position, especially if you're from China or India, to be sponsored for EB-1B, then you should take it, but you have to stay in the job. So you have to stay in the job for however long the backlog is until you can file the 485, plus 180 days after filing the 485, and then you could change jobs to a same or similar position and still keep the green card. National interest waiver, you have to have an advanced degree, which all of you do, and you have to show your work is in the national interest. The legal case is called Matter of Danisar that governs national interest waivers. There's a 3-part process. Number 2 is that your proposed endeavor is of substantial merit and national importance. Everyone here is going to meet that. Your work's either benefiting healthcare, the economy, the environment, education. Number 2 is you're well positioned to advance the endeavor. That typically means you have a job that you are working on, or a job offer, where you can show that, you know, if immigration gives you a green card, you're going to keep working in your field. Based on this, you're allowed to file before you graduate your PhD, but I really don't like doing that. I'd rather you graduate your PhD and then file, because if you're in your OPT employment, at least you show immigration you have a job. If you're applying from outside the US, you don't need a job. You can apply without a job offer. It helps if somebody is offering you a job and they would say, hey, we would consider hiring Dr. So-and-so if they had a green card. It's always best if you can come to the US first in a non-immigrant status. But even without a job of any kind, if your credentials are strong enough, you can still be approved for NIW. And then the third is, on balance, it's beneficial to waive the labor certification. In other words, we're not going to care about US workers. Your accomplishments in your research are strong enough that the Immigration Service wants to give you a green card. They want you to keep researching in the US. Premium processing, I talked about that a little bit earlier. You can premium process any of these petitions I talked about for $2,500. You're going to get a decision within 15 days for EB-1 and 45 days for NIW. You're more likely to receive an RFE or a denial. Really, the only time it makes sense to premium process something right now is if you're able to file for the 485 right away if your case is approved, or in the NIW context, if you're in H-1B and you need your spouse to get an H-4 EAD, and you need an approved NIW to do that, then it would make sense to premium process. Defining your field of research is extremely important. So you're the one telling immigration your research field. So you have to define it broad enough to cover all of your research. But so in other words, you might have done one area of research in your PhD and then you switched the area in your postdoc. Well, you have to think, how are you going to define your field that it covers everything? And then you don't want it to be too broad, right? Like, you can't say you're a researcher in the field of chemistry. It's very hard to show your work has impacted that big of a field. So something like understanding the molecular mechanisms of protein-protein interactions, if all of your work is about that, then that's a good way to define a field. You also need to think about if you change your job, especially if you're in China, from China or India, and you're in a long backlog, and even the world has a backlog now. So, you have to define your field in a way that if you change your job, your next job is still going to be within your field. Maybe you're not going to do research anymore. Maybe you're going to do medical writing or consulting or something like that. So you have to plan ahead in terms of defining your field. Also, sometimes I have people who do, an astronomy degree, and then they learn all that data science, and then they go and they take a data science job. So you can't say your field is astronomy, you have to say your field is data science. So that's sort of an example of how to define your field. So our law firm, we offer a money-back guarantee for most clients. We employ a team of science writers, and I have been doing this a long time. I really understand, how to prepare a case to give you the best possible chance for approval. We offer free consultations year-round at our website, researchergreencard.com, by telephone, Zoom, or Skype. And, there's an online scheduler where you can just go on, and my calendar's in there, and schedule a consultation. And, again, it's really important to speak individually one-on-one to understand what is right for you. And there's also a way to email and a contact us form. So thank you all. I'm going to send it back now to Tom for questions.
Great. Thanks so much, Brian. And we had a lot of questions come through. And sorry, I'm getting some feedback. Okay. So the first question comes from Anirudh. And Anirudh asks, how important are citations in applying for EB-1? For example, I work in a niche field that not many people work on, so we don't generally get much citations.
So again, citations are extremely important. And if you work in a niche field and you're never going to have a high level of citation, then you're going to have no choice but to file your EB-1 case. And you're going to have to sort of explain to immigration that you're in a niche field and that your citation level is high. But what immigration does sometimes is they will look at your co-authors And if your co-authors have a lot more citations than you do, then that sort of minimizes the argument that you're in a niche field. So you have to be careful about that. So, you sort of have to work with your own credentials. And at some point, you have to try an EB-1 to avoid waiting. And you just have to, prepare a good strategic case and be creative. And that's where, a lawyer can help.
Okay, great, thanks. Next question comes from Alan, and Alan asks, if you are rejected for visa/green card status, is that registered in your applicant record? ? Do you have to wait ? And does that affect future attempts?
So a visa rejection and a I-140 rejection are two different things. So if we're just going to focus on the I-140 rejection right now, every time that you file an I-140 petition, there's a question, has an immigrant petition ever been filed on your behalf? So you have to affirmatively answer that question, yes, if you have filed before and been denied. So immigration is going to know that you are denied. As I said, if you're denied once, it's nearly impossible to get approved a second time. Not impossible, but nearly impossible. But the denial of one category does not affect another. So there are many times where somebody's denied an EB-1A, but then they're able to secure EB-1B sponsorship, and then they can get approved with EB-1B. Or, if you're denied an EB-1A, it should not affect an NIW approval.
Okay, great, thanks. Next question comes from David, and David asks, are postdocs at national labs considered academia or industry?
Academia. National labs are exempt from the H-1B lottery, so that is the answer to the question.
Okay, great. Next question comes from Adarsh, and they ask, is the USCIS scrutiny higher for premium processing filing when we petition for EB-1B as compared to regular filing?
So no, that's the one case where I find that EB-1B premium process cases are treated reasonably, where they're really not with EB-1A. And we've been also seeing that NIW premium process cases are treated more reasonably. So, again, most people are going to want a premium process EB-1B if they don't have to wait. But again, if you're in the backlog and you have to wait anyway, and you're doing an EB-1B as an initial petition, I would not premium process it.
Okay, great. Next question is, can you get a green card even if you're not currently working? An example would be a J2 dependent. Do I need to be hired/working to get a green card ?
So the answer is no, but immigration is going to want to know your plans for work. So again, you could apply an EB-1A or NIW out of J2 if you're not working. Your credentials would need to be strong enough to qualify, and you would just tell immigration that you would, if you're given a green card, you would take a job in your field. That being said, if you're in J2, you're entitled to a J2 EAD. So immigration could say, well, how come you're not getting a work permit and working? And they do have the right to deny your case if they feel you're not going to work in your field, right? They're giving you a green card to conduct research, not to drive Uber or deliver packages for Amazon. So there's always a concern that if you don't have a job, what are you going to do with the green card if you get it?
Mm-hmm. Yeah, makes sense. Next question is, does one need to enter the lottery system if one is currently on H-1B academic but is planning to transfer to industry?
So the answer is yes. If you're in academic H-1B, then in order to work full-time for industry, you would have to win the lottery and be sponsored for effective October 1st. There are two ways for you to work in industry otherwise. Number one is the O1A that I talked about. And number two is, not everybody knows this, that if you are working for an academic employer in a cap-exempt H-1B, either part-time or full-time, then you can have a second H-1B job with an industry and not have to go through the lottery. So you get two H-1B approvals by immigration, one for the academia, one for the industry. You're working two jobs, and the academia one, you can be part-time or full-time, and then you'd also have part-time for the industry, and you don't need to go through the lottery. So that's a good way to work for industry, in this cap exempt H situation.
Yeah, great advice. Next question is, does the type of publication matter? Research papers versus reviews, journal papers versus conference.
So, conference is not as given as much weight as journal papers, but, with journal papers, it's all about your publications, your citation level, and your accomplishments. And nobody's going to have just review papers, right? So everybody has, research papers, and then any review paper on top of that's helpful because it helps get your site level up.
Okay, and I think you touched on this a little bit, but can the person working in industry apply for EB-2 or EB-1A?
You can apply for anything, right? It doesn't matter whether you're working in industry or academia. You are eligible for EB-1A, EB-1B if it's qualifying, or NIW. And it's just how are you going to manage your status and what country you're from and the backlogs, and that is all individually unique, right? If you win the H-1B lottery and you're in industry, then you're in great shape to file a petition because you can stay in H-1B indefinitely.
Mm-hmm. Okay, great. Next question is, can an EU citizen who is a PhD holder working in the defense industry in Europe self-petition for an EB-2 NIW while not living in the US?
Yes, absolutely yes. You can apply for a green card from outside of the United States. I would say to you first, are you able to get a job in the US and come in J1, H1B, or O1? If not, the next best thing is to get a letter from somebody, like if you working in defense and Lockheed Martin would say, we would consider hiring so-and-so if they had a green card, then that would be really good to give with your petition. And otherwise, you just give a statement from yourself saying that, hey, if you give me a job, I will if you give me a green card, I will find a job in my field. And then if they feel that your credentials are strong enough, they would approve the NIW without a job. And likewise, same with the EB-1A.
Okay, great, thank you. Next question is, what options do you recommend for DACA recipients? PhD versus non-PhD, if it matters.
So it's a lot easier to get a green card if you have a PhD, but we have many master's level clients that obtain green cards. So it's really based on your credentials more than anything. It's how do you meet the categories? What's your research accomplishments? So if you only have a master's and you qualify, then you're certainly not prohibited from filing.
Okay. Next question is, I'm currently trying to prepare my case for EB-1. However, it is extremely difficult to find, quote, independent recommenders. Do you have any suggestions to improve my odds of getting such letters to improve the strength of the case?
Sure. So the best way to get independent letters is through referrals, right? So you need to ask your colleagues, your PI to refer you to people. Who have you met at a conference? Who has reached out to you? And you can't be shy, right? You might need to ask 50 people to get 5 people to say yes. And eventually you will find independent authors. So just kind of, use your network of people and your colleagues to refer you. That's the best way.
Okay, great. And next question is, I will get my PhD in 2 years, and I'm currently on my F1. Can I file now, or will I lose my OPT extension of F1 status if I lose an EB-1 case?
So the mere filing of an I-140 petition does not prevent you from getting the OPT or the STEM EAD. Again, I would not travel outside the US and return with an F1 visa after you file an I-140, but you can still get the OPT. However, EB-1 is trying to demonstrate you're among the small percentage of scientists at the very top of the field in the entire world, and they're comparing you to all researchers at all career stages. So no matter what your credentials are, how are you going to convince immigration that when you don't even have a PhD yet, that you're at the top of the field in the world, right? So that's something you need to be aware of. And, you know, again, I talked about how it's always better to at least wait until you have a job and graduate before applying. But EB-1 would be really, really hard before getting a PhD for that reason, even if you had 2,000 citations, right? I mean, they're just going to say, you know, I've seen decisions, right? You're too early. You're not at the top of the field. You don't even have a PhD, and that has to make sense.
Yeah, no, that makes a lot of sense. Yeah, next question is there a limited number of times for applying to the NIW? Can I apply with my master's, and if I get rejected, apply with my PhD again?
Yeah, so as I said, you can apply as many times as you want, but they're going to say, we rejected you before, what is different now? And, you know, so you need to certainly wait a good period of time till you had much better credentials, and then, you know, think about it. And I come back, what is the need for the green card, right? You have to think about that too. If you're going to have OPT EAD, if you're going to be able to be sponsored for H-1B or whatever, then why are you looking for the green card so early when you understand that there's a risk of the denial making it harder? But, you know, to directly answer the question, you are allowed to apply as many times as you would like.
Okay, great. Next question, I thought this was an interesting one. Would patents count as O1A recognized achievements?
So patents are not a different category. They would go under the original scientific contributions of significance, but immigration really only gives credibility to patents if they're commercialized. If they're not commercialized, I still mention them and include them, but they're really only going to be given weight, and a lot of weight, if they are commercialized, which is very rare. You know, most people have the published patents and they're not commercialized. But yes, you would include them in any petition that I've talked about, but it's under the original contributions category.
Okay, got it. And another question around the independent recommendation letters. This question is, can the independent recommendation letters be from someone who graduated from the same school as you?
So no, they are not independent, right? There is a bias in one alumni helping another alumni out, right? So, you know, I went to Duke. So if someone were writing a letter for me, then anyone else from Duke, of course they're going to help me. They're going to want to help a fellow Duke alumni. So you want to independent. You should not have anybody that's ever worked or gone to school with you anytime ever. The only letter you should have from someone at your institution is from your supervisor. And again, there's case law on this. Immigration calls it the circle of colleagues.
Got it. And Brian, you also wouldn't want to ask for one from someone from UNC, I imagine.
No.
Next question is, since we self-petition, how do we show what we'll be continuing to work on in the area of our expertise?
So the answer to that is, if you're already working, you have your current supervisor state that, you know, such and such employer will continue to employ you in a research position in your field if you're granted a green card. And then it's just an intent to continue to employ. It's not a commitment to anything. So that's how you show it. And then you also give a statement with the petition stating that, you know, you presently intend to continue your current employment, and if you change jobs, you will continue to work in your field as you define it in the petition. And that's where the field definition is so important.
Okay, got it. Next question is, can you apply for EB-1A and EB-1B parallel to one another?
Yes, you can. And you normally wouldn't do that because the EB-1B is much easier, and, you know, you'd have a much higher chance of approval. The only real way to do that is, obviously, it gives you the flexibility of changing jobs when you're in this backlog. But so for that reason, yes, you might want to do both, and you certainly can.
Okay. And next question is, how long between H-1B and getting your green card? So I guess what's that timeline look like?
Right. So it's an impossible question to answer because of the backlogs, right? So we just don't know month to month what's going to happen with the backlogs. The government fiscal year starts over in October, and that's usually when dates move forward because more visas become available. But, you just have to manage this now, and this is, again, it's a new world with the backlog for the world NIW.
Mm-hmm. Okay. Great. Well, Brian, thanks again for a wonderful presentation today. If there's one important lesson that our listeners should learn from our chat, what would that be?
Sure. It's to have an understanding of where you are right now with your status and where you're headed. Have open communication with your employer about sponsorship. And if you want to live and work in the United States, then apply for the green card. Don't wait if you're qualified. The sooner you apply, the sooner you get into the waiting line. And again, the United States is welcoming researchers, right? The country wants people who are doing the type of research that you're doing. So I want you to feel positive about your immigration status and being able to get a green card if it's what you want.
All right. And I think we're going to, okay, here we go. Before I hand it back to Eric to wrap things up, I want to go over just a few of our ACS career resources offerings, starting with virtual office hours. So this is a monthly event. We run the first Thursday of each month from 12 to 1:30 p.m. Eastern Time. Every month has a different theme. Our next event will be on entrepreneurship on Thursday, June 1st. This free event is going to feature a few different entrepreneurs, and also attendees will have the chance to ask questions to career consultants and network in small breakout sessions. You can visit www.acs.org/career consulting to learn more and register. Just a heads up that these slides are also going to be emailed to you, so don't feel as though you need to jot down these various links. I also want to highlight our personal career consultation program. This is it's a member exclusive program. Virtual office hours, I should mention, is open both to members and non-members alike. And our personal career consultations are just for members. But team members are available to review your resume, conduct mock interviews, help you update and optimize your LinkedIn profile, and provide general career advice. And you can visit that same website, www.acs.org/career consulting, to access our consultant directory and request a one-on-one appointment. And finally, I just want to let everyone know that LinkedIn Learning is now included as a benefit to ACS members who have the premium package. LinkedIn Learning, for those who aren't familiar, is an online provider that offers thousands of on-demand courses, including courses in business, tech, creative, and personal development. And also just note that right now, LinkedIn Learning is not available to ACS members in China or Russia, but it's something apparently that's being actively worked on. And with that, I'll hand it back to you, Eric.
Well, wonderful. We want to thank Brian and Tom for their time as they wave goodbye and for joining us today, providing those tips for how foreign scientists can win their EB-1 and NIW cases. Are you going to the fall 2023 national meeting in San Francisco from August 13th to the 17th? Well, then join today's speaker, Brian Getson, for a free overview and more personalized advice for those seeking to maintain their status and obtain a green card. If you enjoyed today's webinar, we invite you to register for more upcoming free broadcasts. Next Thursday on May 18th, join a panel of chemical safety experts as they discuss how and why to organize chemicals based on hazard categories, as well as the best practices for maintaining chemical storage areas. Then on Wednesday, May 24th, we welcome back ACS webinar fan favorite Matt Grandebois, a strategic partner manager at DuPont Electronics and Industrial, as he dives into the mysterious world of strategy and shares some practical, actionable tips on how you can improve your strategic mindset. The next few decades will require billions of tons of carbon dioxide to be pulled from the air and permanently stored to address climate change. Join us on Thursday, June 1st to discover how carbon companies will be able to achieve energy efficient and low cost processing systems at scale, which the entire world can afford. We'd love to hear what you thought about today's program. You can reach out to us through the ACS social media channels of Facebook, Twitter, LinkedIn, or by email at acswebinars@acs.org. We're also curious to hear what you thought about today's broadcast. A short survey will pop up directly after the webinar that will just take a moment to complete. Also remember that an invitation email to view the recording from today's presentation will be sent to all registrants for a 24-hour period, after which it will be removed, edited, and become an ACS member benefit. And that wraps up our program for today. On behalf of all of us here at the ACS Webinar Studios in Washington, D.C., thank you so much for joining us, and we hope to see you again next week.